Hello, welcome to this video on the Insolvency England and Wales Rules 2016. I'm Rebecca Catterson, Head of Practical Law, Restructuring and Insolvency. Today we're going to be talking a little bit about the new rules, when they come into effect, their structure, some of the pitfalls that their implementation may involve, some of the bigger policy changes to look for. And we'll also be finishing up looking a little bit ahead at 2017 and some of the other developments to expect. The new insolvency rules will be replacing the Insolvency Rules 1986 in their entirety. Effectively, this means that we're getting a completely new piece of secondary legislation which will dictate day-to-day processes of the insolvency procedures. They are coming into effect on the 6th of April 2017. They've been a long time coming in. The main three things that they're supposed to be doing are, one, to consolidate all the amendments to the Insolvency Rules 1986 which have happened in the last 30 years. And that is stated as their principal aim. To be honest, it's not a huge thing for practitioners necessarily, because we all work with consolidated text now. The second thing is that they're going to restructure and update the language and the format, and we'll come on to the ramifications of that. And thirdly, they're going to affect some policy reform. So there are some key changes to how insolvency procedures are conducted on a day-to-day basis, and those will be affected through these new rules. The government really first started consulting on these in 2007, and then the proposals were shelved for several years because there were so many comments on the rules, and I think what was realised was that there was a massively complex set of changes that hadn't really been thought through. I think there had been such a long delay. I think although these rules have been heralded for a very, very long time, I think many practitioners did not think they were going to be coming in at all. And they are now coming in, and I think practitioners are now thinking this is going to be really quite a serious transitional process because so much is changing. The first sort of main way that the structures have changed are on an individual rule level. The actual wording has been restructured so that passive is avoided. They've updated language to make it gender neutral, for example, and generally tried to iron out some inconsistencies and so on. And then there is a second level of the whole restructuring, which is that the whole order of the provisions has changed. So, for example, in the current rules, the 86 rules, the order of the provisions is that each part of the rules deals with a different insolvency procedure, and that insolvency part number roughly mirrors the part numbers of the Principal Act, the 1986 Act, Insolvency Act. That kind of overall macro structure is now changing. One reason for that is because the government has decided that the beginning of the new rules, they are going to introduce a set of interpretation provisions, which is actually probably going to be very helpful. It's nice to know what we're dealing with up front. But that then puts the sort of part numbering off to begin with. The second set of changes come from the fact that they are splitting out the existing part, say the parts dealing with liquidation. There are three types of liquidation, and so they will each be having their own separate parts. So creditors' voluntary liquidation will have a part, members' voluntary liquidation, and compulsory liquidation. And currently those rules sort of mash together. So that will actually be very helpful because currently, often you are looking on a rule-by-rule basis to try and work out what type of liquidation it applies to. There is then a sort of further slight change to the current approach, which is that where different processes have provisions that apply to each process, but at the moment they are sort of common provisions, but they are written out separately in relation to each current process, and there are just differences between them, unintentional for the most part. But you never quite know. So it has been so far very important to really sort of work out what the exact drafting is and what process you are. These parts are going to be collated and put into a set of common parts, they'll be called. And so we've got new common parts relating to creditors' voting, decision type making processes, distribution rights, and so on. And those are sort of more bundled up towards the end of the rules now. So overall, the premise in the current rules is roughly the same in that you have a part dealing with each different type of insolvency process, but the numbers that we practitioners now currently sort of know and just know their way around, are now changing. The key policy changes are broadly already very much known about to start with, because they will require changes to the Insolvency Act. And a lot of these already sort of been brought in. They're in effect for the purposes of making further rules. So these changes have been effected to the Insolvency Act by the Small Business, Enterprise and Employment Act 2015. And they will come fully into force in April when the rules come in. So we have on that basis, we have these changes that are going to the principal legislation and this new secondary legislation. There are a number of different headline changes, and some may assume more importance than others in day-to-day practice, actually, and we've yet to figure out how fundamental some of these will be. The one to lead with is generally the abolition of creditors' meetings as a default way of making decisions. So currently, the default thing is that an insolvency office holder will summon a physical meeting, and that obviously there will be a cost to that. And if no creditors turn up, then there's still a cost to the insolvency estate. What's happening is that is now being abolished as a default action, and it will be for the insolvency office holder to decide how he wants the decisions that creditors would be making for him to be made. And so I think what will be a most popular form of decision procedure will be this new thing called a deemed consent procedure, which is whereby the office holder will circulate the proposed decision and what the decision is, and it will be deemed to be agreed to unless a certain amount of creditors object, and that would be 10% in value of creditors. That can easily be interrupted by creditors who can decide, no, we want to have a proper meeting about this. And if you have 10% in value of creditors by number or value, or 10 individual creditors, they can compel the summing of a physical meeting in almost all circumstances. There are other types of ways that you could hold meetings. There are virtual meetings, which are effectively meetings that would be held by telephone, by web conference, and so on. There's correspondence, so decisions can be made through letter or so on. And then there is a form of electronic voting as well, which should probably be used in the context of virtual meetings. So there's this whole new shift to ensuring that decisions get made, but not necessarily by creditors in meeting, voting in person or by proxy. In keeping with the idea of virtual meetings and getting rid of physical meetings, there's a general move towards an increase in enabling the use of electronic communication, by which generally we mean email, but there's all sorts of forms of other possible things. And one big thing in the rules is that government is very much trying to future-proof, as they call it. So they're aware that different methods of communication are developing, and they're very keen not to have to amend the rules to allow, in future, for notices to be posted in different ways, for formats other than email, but which are still somehow electronic, to be used. So effectively, what is now happening is that insolvency office holders will be able to continue communicating with creditors where the debtor had always communicated with the creditor by email. And so the office holder will not need to seek permission before continuing that format of communication. It will also be made easier for office holders to, instead of posting notices to individual creditors, or requiring their permission before they put all notices on websites, that will now be made much, much easier without a lot of interim permission from the court, for example, to do that. Another thing that's happening is that the timing of the creation and circulation of progress reports is being standardised. Currently, the cycle of producing a progress report in individual types of insolvency process can be thrown off. That cycle will be thrown off if the insolvency process is extended, for example, administration is extended, or it's transferred to a different individual who will become the office holder. Now, the cycle that you're on, your 6 or 12-month reporting cycle, will continue regardless of what is happening, regardless of whether the insolvency process is being extended or transferred or so on. So that will actually remove some ambiguities and difficulties that have been around for a long while. Another change is that this is more, I think, more of a data protection thing, but statements of affairs now, there is a move to enable the protection of the details of individuals, whereby individual creditors don't have their names automatically put in the statement of affairs, which is made public. So where a creditor is an individual and a consumer, or an employee or ex-employee, their names will be listed as creditors, but in a schedule to the statement of affairs. So it will no longer be automatically visible. And a final point, which will actually potentially be quite significant, is that insolvency office holders will no longer necessarily need to require creditors with small debts, which is debts less than £1,000, to submit a formal proof of debt. They can go from the statement of affairs or from the company's accounting records and just pay the debt. So that is intended to obviously cut down a lot of paperwork and unnecessary chasing. The rules are over 450 pages long, so there is going to be, unfortunately, no substitute for just going through the rules, largely through worked examples. So as lawyers are practicing, it will be interesting. That is the best way to learn. But obviously at the moment, in practical law, we are going through the rules, rule by rule, and making sure and updating all our existing materials. So some things are coming out already, and we will be publishing sort of more details on that. And I think there are a lot of things that are coming out on the Insolvency Services blog that they've introduced, where people are just asking questions as to, is this oddity intentional? To give some examples, though, I think a first one is that the rules are helpfully in many ways making clearer how the civil procedure rules apply to the service of notice and so on. And they're also making clear how they apply to the calculation of time periods. And these are things that practitioners have historically been very aware of being caught out on, because they can actually have big consequences to validities of processes, or at least of that particular notice. So I think one thing to notice is that there's a new definition of day is a clear day, not. And so, I mean, that's just something that will then have to feed into an awful lot of calculation of time periods. Staying on the idea of serving notices, another point to note is that notices of intention to appoint an administrator are now deemed to be claim forms. And this is just a complete change. It's not necessarily going to be particularly problematic, but it does give rise to some questions. I think one of the key ones that certainly we've begun to formulate is, well, where something is treated as a claim form for the purposes of the civil procedure rules, there are further formal requirements in how you serve the claim form. And particularly, for example, if you are needing to serve that notice of intention to appoint out of the jurisdiction, under the CPR, you do need, permission of the court to serve that out of the jurisdiction. So there's a question as well, would you need that level of permission? It seems that shouldn't be needed, but equally well, that's how it would work through. And I think finally, the example I would give is again related to the appointment of administrator. And this is where a qualifying floating charge holder seeks to appoint an administrator. But there is a qualifying floating charge holder who has priority over the one who wants to appoint. And so currently you need to give notice to the prior charge holder, and you need to give them a certain amount of notice, and they can effectively waive that level of notice by consenting to the appointment. And under the rules currently, the prescribed form for doing that has had a form of consent slip attached to it, and also the actual formal requirements for that type of consent have been listed in one of the rules, and neither the form will exist, nor will a corollary of that rule which specifies what that consent has to contain exist under the new rules. And that does seem somewhat of an oversight, particularly as I can also point out, I think at this point, the forms themselves will be abolished, and the whole point of the new rules is that they will be specifically listing all the requirements for various notices in long form. So it does seem a rather odd point to have missed this particular chance to list out what this contents of this consent should be. As providers of a suite of content which helps lawyers as a guide to sort of daily processes, our absolute priority would be make sure that our materials are absolutely up to date and reflect the new rules at the point they come in, obviously overnight on the 5th of April. The thing about the new rules is that they do come in for all insolvency processes. So they will not just be applying to processes that only become on foot after that date. They will apply to everything. So they will reflect the law as it applies to all processes, in other words. So we won't have a sort of an old set of materials and a new set. We will just have this one set of materials which will reflect the law as it applies everywhere. There are minor transitional provisions, so we will be producing further guides to that and linking that into our materials. In terms of bespoke content and guides to different aspects of the new rules, I've already mentioned that there's this whole sort of form of decision-making procedures, and we're producing a very detailed note on that. We will also be producing a note on this new procedure whereby creditors can opt out of receiving further correspondence should they wish to. Again, there is a level of detail to that which is I think we need to have some specific content on that, which I think people will find helpful. Sort of the bigger, and for many, the sort of elephant in the room is this whole point about the insolvency forms being abolished and replaced by rules which just write out the form of content of notices that will have to be communicated by email or by whatever. And I know there have been a sort of a number of requests sort of in the industry to, well, is anyone going to create new precedents? Because there are hundreds of insolvency forms which will no longer be available. And I think people are rightly concerned that, you want to make sure that your notice is right and complying with both the requirements of any individual rule, but also this extra set of standard content, which the rules also say has to be in any of the notice. So it sounds nice that you just have a nice sort of informal-ish rule setting out, your email has to include this, but actually there are pitfalls which people will be, rightly slightly concerned to avoid. So we will be producing a set of precedents. I think it will be an ongoing process, but to begin with, certainly the key forms, the appointment of administration, liquidation forms will be certainly something we'll be covering, and we'll be sort of looking to expand that. In 2017, forthcoming developments, there will be a few actually beyond and above the rules. On the 26th of June 2017, the recast insolvency regulation will come into force. That will only apply to processes that are started on or after the date that it comes into force, unlike the new insolvency rules. But there are quite sort of a number of large changes that practitioners will need to be sort of getting to grips with. They've been well previewed because this regulation was made 2 years ago, well, 1.5 years ago, 2 years by then. And we have a range of materials covering that. We're also shortly to publish a black line showing exactly how the text is changing. So that will be something big to be dealing with if you are dealing with cross-border insolvency cases within the EU. The second big development this year, which is actually potentially bigger than the forthcoming insolvency rules, is the next steps on the government's recent consultation on changing corporate restructuring law to include a wide-ranging moratorium on creditor action. This was consulted on last May, and the consultation closed in July. The government were intending to give their further responses to that, I think, within 3 months, so they're well overdue. Since then, however, the EU Commission has issued its own proposal for a directive which would apply EU-wide and require effectively EU member states to have forms of restructuring laws which mirror what the government here has already been consulting on. So obviously, the government here very much wants to be leading on this and being seen to set the standard on what a good restructuring law will contain. Those proposals therefore look like they very much will come into force in some format. A big thing to note about them is that they are, or certainly the EU Commission's version of them, is very much based on Chapter 11 in the US. So obviously people have different views on how effective they are, and there are pitfalls, no doubt, that happen in the context of US Chapter 11 that can easily be avoided here. But it certainly does signal something of a sea change for our whole format of restructuring law in the UK.